The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to the Law of Self-Defense weekly news and Q&A show. For those who may not know, I am attorney Andrew Branca. Thank you very much. I really appreciate that. This is our weekly news and Q&A show for October 1st, 2020. This is the only weekly content we produce that does not require membership at the Law of Self-Defense. And of course, we make it open access in an effort to expand and grow the Law of Self-Defense community. In the show, we cover self-defense events in the news, as well as take your questions. Now, a bunch of questions have been sent in to us ahead of time. We are always happy to receive those. If you're a Law of Self-Defense Platinum level member, we encourage you to use the Platinum member Q&A form on your member dashboard. Those questions get obviously prioritized. Anybody else, however, can also send those questions at show@lawofselfdefense.com, and we'll take those under advisement for an upcoming show. So come on in, folks. If you are watching this live, and we do this show live every Thursday, 4 p.m. Eastern Time, our members can catch it on their member dashboard at lawofselfdefense.com, or you can watch it live on our Facebook channel, facebook.com/lawofselfdefense, or our YouTube channel, youtube.com/lawofselfdefense. And after the show airs, we also have a replay of it available, again, open access at the Law of Self-Defense blog, which is simply lawofselfdefense.com/blog. So come on in. If you are watching live from Facebook, if you could click that share arrow at the top of the comments, click that thumbs like button. That's always appreciated. Helps us grow the Law of Self-Defense community. If you're watching this on any social media, if you could leave your city and state, that always provides us with helpful geographic information to help customize our content. So before we jump into the show proper, I do, of course, feel obliged to mention our sponsor, which is CCW Safe. Let's see if I can get that slide up for all of you. Okay. Try it one more time. There we go. Success. So CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members' legal expenses if the member is involved in a use of force event. There are a number of companies that offer this kind of service. I've looked at all of them, as you might imagine, and I found that CCW Safe is the best fit for me personally. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you, of course, is something only you can decide. But I do encourage you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member at that URL, you can save 10% off your membership with them using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay. Now, as I mentioned at the start, this is the only show that we do every week that's open access, that does not require membership. Our members get almost daily blog posts. For example, a couple of cases we covered this week. We did a blog post on another self-defense insurance company, quote unquote, USCCA getting sued in federal court for not paying their members' legal expenses in a use of force event case. We also covered the case of Michael Strickland, who's back in the news because he wrote a guest blog post on a blog called The Gateway Pundit. So we reviewed his case, the facts of his case, his recently failed appeal of his convictions earlier this year, and now his efforts to bring his case to the U.S. Supreme Court. That's the kind of content that only members get. The good news is that membership, folks, is dirt cheap and even cheaper now than usual. Normally, a standard membership at Law of Self-Defense that gives you access to all our weekly blog posts, video content, and our members-only podcast is only about 33 cents a day. It's under $10 a month. But even better, you can try it out for 2 weeks for just 99 cents, folks. 99 cents, that's it. At lawofselfdefense.com/trial. You get all the same access as any other standard member for that 2-week period. If you decide it's not for you, which very few people do, we will not only give you back your 99 cents, we'll give you back 200% of your money. Granted, it's only another 99 cents, but let's face it, you didn't put up all that much to begin with. So it's a negative risk opportunity, folks. If you like this kind of content, something you should know by the end of today's show, then our 99-cent standard membership 2-week trial ought to be something you consider seriously at lawofselfdefense.com/trial. Okay, let's jump into our content for the week. Not that one. Let's try it again. There we go. Okay, so I had a number of excellent questions come in. One came in from Robert P., who's one of our Platinum members. He's in New York, and he's writing about the subject of self-defense insurance. The particular one he was looking at isn't really relevant here, so I'll just leave it generic. But he writes that his wife and he were members of a quote-unquote self-defense insurance company until spring of 2020, when they learned that the state in which they live, which is New York, had effectively banned those kinds of policies. A number of states have put pressure on these companies that offer these services. New York, Washington, there are one or two others. I don't recall exactly which ones they are, but in effect, they make it so difficult to offer these policies in those states that the companies that provide quote-unquote self-defense insurance exit the markets of those states. He says that he feels this seriously undercuts his ability to defend himself in court if they were so unfortunate as to have to defend themselves with lethal force. With this liability hanging over our heads, it seems it may be prudent to stop carrying a lethal weapon and hope for the best. Moving presumably out of New York State, would be difficult at this time. Can I comment on that? Yes, there's quite a bit to comment on here. First of all, any kind of self-defense insurance, legal service membership, should not influence your decision-making in self-defense at all. For example, in a deadly force confrontation where you may be using a gun potentially to shoot somebody, potentially to kill them, you should be doing that only if you're facing an imminent deadly force threat. And if you are, you need to defend yourself. And if you're not, you ought not be shooting that person. And whether or not you have self-defense insurance shouldn't change that equation at all. So it shouldn't change your decision-making. Now, it's true that if you don't have that kind of coverage, that kind of legal service membership, it can substantially undercut your ability to defend yourself in court in terms of the legal battle. Unfortunately, I'd like to live in a world where how much money you have doesn't affect the kind of justice you get, but legal defenses are expensive. If it's a murder case, it's going to be extraordinarily expensive. So the more resources you can bring to that fight, the more likely you are to win, meaning get acquitted. And when we're talking about cases that can easily run into the six figures pre-trial, before you ever get to the trial, and a multiple of six figures once you actually get to trial, we're talking a lot of money. So it can be very beneficial to have that kind of financial backing. It's one of the reasons we're pleased to have CCW Safe as a sponsor of much of our content. So it can, not having such a policy can undercut your ability to defend yourself in court, but it shouldn't have anything to do with your decision-making about defending yourself or your family or your property tactically in the moment when you have to make your use of force decisions. You certainly should not be deciding to use more force or under broader circumstances just because you have a financial backer for your legal defense. Remember, how much money you can bring to the fight may help you get acquitted. It doesn't guarantee an acquittal. You still are facing the risk of prospectively spending much of the rest of your life in jail. Now, Robert also suggests that he's thinking perhaps, well, with this risk, maybe it's not worth carrying a lethal weapon. And this is a thought that occurs or is expressed to me by many people who go through my courses. For example, after listening to me talk for 6 or 7 hours about the great legal peril that occurs once you've used or threatened force against another person, it's pretty common for people to say to me, wow, I did not know this was so risky. I don't think I'm going to carry a gun anymore for personal protection. Well, that's not the point of our courses. The point of our courses is to make you aware of the risks so you can accommodate your behavior, your conduct in self-defense within the legal boundaries to mitigate those risks as close to zero as possible. It's not to convince people to go unarmed. I teach the class and I go armed every day. I have for my entire adult life. So I'm certainly not trying to discourage people from carrying concealed. And let's face it, folks, are you just going to take the deadly force beating? Is that the decision you're really making if you decide simply to leave your gun at home? Now, there's good reasons not to carry a gun. Not everybody should carry a gun. You all have to make that decision for yourselves. But whether or not you have self-defense legal insurance, to my mind, should not be a substantial factor in coming to that decision. Let's see. Okay, we have another question here from David M., also a Platinum member. And folks, if you want to put questions into the comments, I will get to those time allowing as well. So feel free to put questions into the comments, either about stuff I'm talking about or independent questions that come to mind, and I'll do my best to flip through them before we close out the show today. So we get a question from Dave M., also one of our Platinum members. He's in Delaware. And Dave says, Andrew, yesterday's member-only expose regarding the false narrative of excessive police on black murders. So this was a blog post I wrote last week he's referring to, in which essentially I asked if there's such systemic, unaccountable police racist murder happening, where are the actual cases? Because all the cases I see publicized in the news are not, in fact, cases of systemic, unaccountable police racist murder. In fact, I'm aware of no case of unaccountable police racist murder where there's not a completely viable explanation for the police use of force that has nothing to do with racism. So I had written that blog post, and I know some of you are thinking, well, there's clearly examples, Andrew. There's George Floyd, there's Breonna Taylor, there's none of them, folks, not one of them is an actual case of systemic, unaccountable police racist murder. Not one. So I had written that blog post, and that's what Dave is writing in response to here. He says, many of his friends are buying into those fictionalized accounts. Many are not gun owners, would therefore have no desire to be a member of law of self-defense. Well, law of self-defense is not just for gun owners, folks. We're weapon agnostic. I don't really care what weapon you may use to defend yourself. The same use of force law applies. But in any case, he says they're not likely to be members of law of self-defense, but they would be well served by hearing that message. The message that there is, in fact, no systemic, unaccountable police racist murder happening in America. Could I make the post public? Well, the trouble with making those posts public, folks, is that I have members. And the members pay to be members. And the members pay to have privileged access to that content. Now, for most of them, they're paying about 33 cents a day. So we try to make it as affordable as we can. But if I reduce the cost to 0 cents a day, well, then I have to go do a normal legal practice all the time, and you won't have this content. So we're hoping that 33 cents a day is the price that people are willing to pay to access this content. Obviously, many of you are. And we do this one show, our weekly Thursday, 4 p.m. Eastern Time news and Q&A show that's open access for everybody to give the general public who are not yet members an opportunity to get a feel for what we do, how we do it, and see whether or not they feel that for them, the content we deliver is worth 33 cents a day. Hopefully, for many of them, it will be. If it's not, that's just the way the cookie crumbles, folks. So then I got a very interesting question from Antonio E. This is an email message. And he asks if I'm familiar with the mini verse monster concept. Apparently this was created by, I mangled the names here. Perhaps it's David Myers and John Peters, David Myers, and promoted by John Peters and Masa Ayub as it relates to disparity of force. And he sent me an image that represents this concept of mini to monster, and I think I put it together as a slide here for all of you. Yes. So this will cover up the whole screen, but I had to make it that big in order to make it useful for all of you to be able to see it. So let me put that up on the screen now, and then I'll kind of talk through what I think is the concept, because I have to confess, this is new to me. I'd not heard this before or seen this graphic representation of this idea. And of course, the idea is very simple, really. It's that where there's a disparity of size, the larger person is more likely to win the fight than the smaller person, assuming, as is assumed for purposes of this exercise here, that the persons have equal training and equipment. I'm not sure about the equipment. I mean, they call a gun the great equalizer for a reason. Once the gun is in the equation, then certainly this wouldn't apply. But they say here at the top, disparity of force in a hand-to-hand confrontation. And the idea is a smaller person is more likely to lose to a larger person in a hand-to-hand confrontation. Which is fine. I mean, I think we can all accept that. It's what I would call common knowledge, like fire's hot, knives are sharp, things along those lines. What they do here, however, is they attempt to apply numbers to this kind of disparity of force, where the numbers here, my understanding is they represent the likelihood of survival. So where there's no disparity of force, I would suggest disparity of size is what they're really talking about. And they define the sizes both by height and by weight categories. You can see that where it says mini, small, medium, large, monster. Where the two parties engaged in the hand-to-hand confrontation are of the same size, that's kind of the diagonal slice through that table at the top, there's a 50-50 chance of survival, and where there's an increasing disparity of size, the percentage probability of the smaller person winning diminishes. So when we have a mini fighting a monster, the idea is here, I believe, the mini has a 10% chance of survival, the monster a 90% chance of survival. Meaning, of course, the reverse is also true, right? The mini would have a 90% chance of dying, and the monster would have a 10% chance of dying. Antonio asks, my thoughts on this. First of all, I was not familiar with this. I had not seen this before. He says he's printed it out and he's made a record so he can demonstrate he possessed this knowledge. Has it ever been used successfully in court? Would it be used successfully in court? Would it be useful? My answer, I guess, would be, well, first of all, we would not know if it's ever been used successfully in court. It's one thing people need to understand about our legal system. We keep very careful records about outcomes of cases that happen at the appellate levels. So the Court of Appeals, the state Supreme Court. We don't keep great records of what happens at the trial level. There's no easy way for an attorney you can't hop on Lexis, for example, and see what's happening at all the trial levels, what decisions are being made, what evidence is being admitted. We really generally don't know anything about what's happening at the trial level unless we're personally involved in the case, or it's a high-profile case, it's in the news, and so there's reporting about it, or we've watched it on video if it's a case that's actually on TV, or it gets appealed. If it gets appealed, then the case appears in the appellate record, and we know about the trial, whatever the Court of Appeals or the state Supreme Court decides to share with us about the trial. We still don't know the whole trial. We don't know anything about the things that the appellate courts don't take issue with, don't discuss in their appellate court decisions about the trial. So what happens at the trial level is pretty much invisible to us, even to legal professionals, unless, again, we're somehow involved in the case or monitoring the case. But that's not true for the vast majority of cases, obviously. So the trial levels is largely invisible to us in terms of things like evidentiary decisions that are being made. At the same time, the trial level is where the evidentiary decisions are being made. So 95% of the legal action is happening at the trial court level, and we don't see it. And the reason we don't track that stuff closely, that a Westlaw or a Lexis service doesn't do that, is because those decisions happening at the trial level are not controlling on any other courts. They're not even controlling on the same court with a different case the next week. And because they're not controlling, they're not precedential in value, there's not much utility to us knowing what happened in a particular case. Now, of course, there are standardized rules of evidence, for example. There are norms that are supposed to apply to evidence, so we can kind of share, if we have experience, share our well-informed opinion about what would likely be admissible or not admissible, but we don't know what's actually happening at the trial level. So would something like this be helpful or important in a trial? And I think we have to look at it from two different perspectives. One is the general idea that where there's a disparity of size, where a small person's fighting a much larger person, that's a real factor in use of force law. That goes to the reasonableness of the smaller person's perception of a threat, the degree of threat, their likely ability to defend against that threat. That's all real. Everybody understands that a smaller person has a harder time in a hand-to-hand fight when they're fighting someone substantially larger or stronger than them. So that general idea and concept is certainly something I would argue in a case if there was a disparity of size between my client and whoever they defended themselves against. And it could be very important, that disparity of size. It could justify, for example, going to the gun, using deadly defensive force, where that use of deadly defensive force might not have been justifiable if the two parties were in fact the same size or similar enough in size. So the general concept is totally 100% valid, no question about that. Is reducing it to this level of detail, these specific numbers, is that useful, or would it be admissible? And I guess the first thing I'd have to ask, because I don't know, is where do these numbers come from? This 50-50%, 60-40, 70-30, 80-20, 90-10. Because unless they're based on actual science, meaning well-controlled studies, good methodologies were applied to generate these numbers, and frankly, it's hard for me to imagine how such studies could be ethically run, unless there's actual data underlying this, research underlying this, that could be presented as a foundation for introducing this summary table, for example, as evidence. I don't believe these numbers would be allowed as evidence because there's no foundation to them. They look to me to be, reasonable but fabricated numbers, not based on anything other than kind of common sense and what we might expect to happen. And the difficulty we run into then trying to introduce something as detailed and numerical as this into evidence is if you're trying to introduce this kind of expert knowledge that you're arguing, well, a jury wouldn't normally be expected to know this because it comes from expert training or experience, something unusual. It's not common knowledge like fire is hot. It's specialized knowledge. The trouble is you can really only introduce specialized knowledge, and I would suggest would be offered. The only reason to offer this is as specialized knowledge. You can only offer it if it's touching on an issue that's outside the reasonably expected understanding of a typical juror. For example, you can't introduce specialized knowledge that fire is hot. Everybody knows fire is hot, unless we're talking about some really ridiculous extreme degree of heat intensity. That could be, I suppose, relevant in the case. But normally the idea that a flame is hot is not specialized knowledge, it's common knowledge. And if a jury would be expected to already understand the concept, there's no room, there's no vacuum that needs to be filled by specialized knowledge. And I think a jury would normally be expected to understand that if somebody's substantially smaller than the person they're fighting, that they're fighting at a disadvantage. Now, they wouldn't have these numbers, but I'm not sure these numbers are real anyway. Now, I suppose... So I just don't see the utility of this level of detail. So I just don't think it would be very useful. And frankly, if I were a prosecutor, I would object to this because I would argue that fundamentally it's either just describing a concept that's already generally understood, so we don't need any kind of specialized knowledge to get the point across to a jury, or it's just nonsense. I mean, it's just made up numbers, which is what it looks like to me. Now, if there's actual research behind this, I'd love to see it. That would be awesome. It doesn't look like it to me, especially given how round and even and convenient the numbers are. Okay, what else do we have? Let me see. Oh, before I go on, folks, we're about halfway through. I do want to mention that we are in 2 days, on Saturday, October 3rd. That's this Saturday, folks. we're doing our last Law of Self-Defense Advanced Live Online class for the year, probably for the next 6 months or so. We haven't even scheduled the first class in 2021, but I'm not planning to do one until late winter anyway, sometime in March, perhaps, maybe early April. So this is the last opportunity to participate in this class for at least 6 months. This is our full day class on self-defense law, what we used to call our level 1 course. This is the same course that's been accredited in more than 30 states for continuing legal education for lawyers. That's the quality of the course, but it's not technical. All the legalese is translated into plain English, so the course is perfectly appropriate for everybody. It is, to my knowledge, the most comprehensive education you can get in self-defense law that's law-based anywhere. And it's happening this Saturday, October 3rd. If you'd like to really have an expert's understanding of self-defense law, folks, to my knowledge, this is the only place to get it. Whether you're a lawyer or whether you're just an armed citizen or just would like to know how the law of self-defense actually works. So if you're interested in taking this, and by the way, folks, if you're thinking, well, I'll wait 6 months to the next one, do you have 6 months to wait? I mean, do you know when you're going to be attacked? We don't get to choose the time, place, and manner of attack, right? The aggressor gets to do that. And we're not living in a time that's getting more peaceful, folks. It's getting more violent and more politically chaotic. And frankly, the prospects of getting prosecuted by a politically motivated prosecutor are skyrocketing for a variety of reasons that are outside the scope of today's show, but which I talk and write about regularly. So your use of force has to be as tightly within the legal boundaries as you can possibly get it, because you can't count on getting cut any slack anymore. It's not going to happen, or at least you can't count on it. So you really want to understand the law of self-defense, this is the class you want to take. It's our Law of Self-Defense Advanced Live Online course. I teach it live, but not in person. We stream it in a webinar format, but there's plenty of opportunity for Q&A. It's a full-day course. It runs from about 9 a.m. Mountain Time to roughly 3 to 4 p.m. Mountain Time, depending on how many questions are asked. And I do stay until all the questions are asked. Sometimes that adds a whole hour to the class at the end. Of course, you don't have to stay for that portion if you don't want to. But you can learn more about this Saturday, October 3rd, this Saturday's class at lawofselfdefense.com/live online. One word, law, or lawofselfdefense.com/advanced. Either will work. Okay, let me get back to the questions. What do we have here? Marty S. writes via email. He says, this may be straying towards the edges of the area of law you cover, but Kyle Rittenhouse's attorneys are challenging extradition. I guess Kyle's in Illinois now, and Wisconsin, of course, has charged him with a variety of felonies, including murder. And Kyle Rittenhouse's attorneys are now want to apparently fight extradition. I saw a news report on that as well. What's the burden of proof in such a hearing, and who has the burden of production in an extradition hearing? For what it's worth, Marty writes, this is still Marty, the narrative portion of the charging information, the charging document, doesn't seem to support the charges. Perhaps I'll introduce it and point out the contradictions. And that's what Marty is asking about. Now, the first thing I'll say is I know virtually nothing about extradition law. It's not my area of expertise. Because it hardly ever comes up, folks. The threshold for extradition is shockingly low. It's barely more than zero evidence in support of the reason why the requesting state wants that person to be delivered to them. Now, in Illinois case law, I took a quick look before the show today. The Court of Appeals has ruled that even a criminal complaint that fails to show probable cause, in other words, a criminal complaint that wouldn't technically be enough for an arrest within the state boundaries, is still sufficient to support extradition from one state to another state. I mean, it's almost boggling. And part of this is that extradition law has, it's designed in the American system to be extremely robust. There's an extradition clause in the U.S. Constitution. I mean, our founding fathers put effort into this. And basically, it requires states, upon the demand of another state, to deliver a fugitive from justice. And all that's required is a claim, really, that the fugitives committed some crime. I think the Constitution technically says treason, felony, or other crime. But other crime's a pretty broad category, folks. Plus, now, one awkward part of the constitutional requirement for extradition is it just says, well, the states have this duty to each other, but it doesn't say, what the conditions are, what the circumstances should be. It doesn't put any actual rules around it. There's some federal legislation, therefore, federal statute that kind of builds an extradition framework, but it reflects that very low standard. So basically, it's just a request from the state executive that wants the quote-unquote fugitive produce a copy of an indictment or an affidavit made before a judge, what many states would call an information, a sworn statement. But again, the standard is incredibly low. Even if it doesn't technically state a crime, it's sufficient to support extradition. And states don't want to hold up extradition requests from other states for the most part because, if that other state has one of their fugitives, they want that guy too. So they all try to play nice. Now, there are kind of exceptions, loopholes to extradition, particularly where the crime alleged is very low level. So it's a misdemeanor, or it's a low-level drug offense, or for a couple of states, like Alaska and Hawaii, they do have a slightly higher threshold for extradition just because of the distances and travel required, but none of those exceptions or loopholes would apply to the felonies charged in the Rittenhouse case. So I do not expect Rittenhouse's attorneys to have any luck fighting extradition in this case. Now, it would be nice if they had a prospect of having luck, right? Because one of the issues in this case, Rittenhouse in particular, is that the evidence favoring a narrative of lawful self-defense is overwhelming. I mean, it's ridiculous that Rittenhouse has been charged in this way. It's going to be tried in this way. Frankly, I see no narrative of guilt that has any prospect of disproving self-defense beyond a reasonable doubt. So Rittenhouse should not have been charged in the first place. If he should not have been charged in the first place, he should certainly be facing some kind of extradition request. And if the charges are fundamentally nonsense, which I believe the Rittenhouse charges to be, but they're being pursued for the political advantage of political actors in Wisconsin, which I believe is the case. In theory, it would be nice if you could have a set of eyes, a judge who's not in that political milieu, not in the Wisconsin political machine, to have him look at the narrative of guilt and give a non-politicized assessment of whether it's adequate to support the charges against Rittenhouse. I'd like to live in the world where that would happen. I do not expect that to happen in this case. I expect Rittenhouse they'll go through the motions of this extradition fight. Frankly, from my perspective, I just hope it doesn't cost them too much money because this case is going to be expensive enough as it is. I know they've raised a lot of money. I heard they're over $500,000 now for the legal defense, and that's awesome. That's good. It may not be enough. 500 was not enough to cover Zimmerman. Zimmerman's defense was almost 3 times that amount. So you need to be prudent about where you're spending your money, even if you have what would normally be considered a lot of it. I certainly would not want to see the defense spending a couple $100,000 on an extradition fight that I expect is going nowhere. That said, I repeat again, my level of expertise in extradition matters is very close to zero. So take all that with a grain of salt. What else do we have? Rodney G, I believe this was email, I forgot to make a note of it, asks about the legal ramifications of using pepper spray in a defensive context. He heard someone on the internet talking about it who he felt didn't do a good job. He'd like me to address it. Well, first of all, we do have to be clear that we're discussing the use of pepper spray in a defensive manner, not in an offensive manner, because the analysis is quite different if it's being used offensively. I would argue that you can make a strong case that an offensive use of pepper spray is a deadly force attack because it's being done to debilitate the victim, presumably to be able to inflict further attacks upon the victim. That's completely different than using pepper spray in a defensive context in which, well, you're just defending yourself, trying to get away from a threat. So we are talking about the defensive context. So to understand kind of how pepper spray works on the use of force continuum, we have to recognize that fundamentally self-defense law places force into one of two buckets. Either the force involved is deadly force, meaning force capable of causing, readily capable, not just speculatively capable of causing death or serious bodily injury. Usually that means a maiming attack, a broken bone, something more than just a modest transient injury. So it's either in the deadly force bucket, meaning death or serious bodily injury, or it's in the non-deadly force bucket. Now, pepper spray used defensively is invariably found to be in the non-deadly force bucket. I have seen it characterized as being in the deadly force bucket, of being readily capable of inflicting serious bodily injury when used offensively. These are mostly bank robbery cases that end up in federal court. For obvious reasons, they're bank robbery cases where the robbers go in and pepper spray all the clerks and everybody to facilitate the robbery of the bank. And then when they get caught, the feds want to charge them with an aggravated battery instead of a simple battery. Well, to be an aggravated battery, it has to be a battery that threatens or causes serious bodily injury. So they want to characterize the pepper spray as causing serious bodily injury, which puts it in the deadly force bucket. And those arguments are successful in the federal courts. But when used defensively, pepper spray is invariably put in the non-deadly force bucket because it doesn't cause permanent injury. It's transient and so forth. Transient pain and discomfort is really what's being inflicted. Now, the reason we have these categories is from a defending position. You're only privileged to use deadly defensive force if you're facing a deadly force threat. Most often, statistically speaking, according to the FBI, Department of Justice, most often, about 5 times as often, you're actually facing only a non-deadly force threat, and therefore a deadly force defense would not be appropriate. Pepper spray, therefore, becomes a very useful tool as a means of defending yourself against that non-deadly force attack. It is, in fact, my personal preference. I carry pepper spray as well as a pistol for personal protection, and the pepper spray for, 1, places where I may not be permitted to carry a gun, and 2, where the threat I'm facing is a non-deadly force threat against which the gun would not be an appropriate response. So I'm a fan of pepper spray. Now, I've talked about these 2 buckets, deadly force bucket, non-deadly force bucket. And it's important also in the context of non-deadly force to understand that within the non-deadly force bucket, there is a continuum, kind of an internal continuum of force. So we distinguish between non-deadly force and deadly force. And then within the non-deadly force bucket, we need to distinguish between different degrees of non-deadly force. That's not true of the deadly force bucket. If you're in the deadly force bucket, there are no distinctions, degrees of deadly force. It's all deadly force. There's not more deadly force or less deadly force. It's force capable of causing death or serious bodily injury, or it's not. But in the non-deadly force bucket, there's a difference between someone poking you in the chest with a finger and someone punching you in the face with their fist, or OCing somebody. So you need to make sure within the non-deadly force bucket that you're maintaining your continuing proportionality within the scope of non-deadly force, as well as between the 2 larger buckets of non-deadly force and deadly force. Let's see. Hopefully that answers Rodney's question. Then I had a few questions come in about my blog on USCCA getting sued in federal court by Kayla Giles, one of their platinum level members, for refusing to meet their apparent obligation to cover her legal expenses under the USCCA Platinum Protection Platinum Plan that they sold to her, that she paid for. I've written about this case several times. I don't really want to dive into all the details again. I think what I'll do instead, those of you who are members have read my posts on this. I think instead of diving into this USCCA escapade again, I'll first flip through the comments that have come in during the show and see if we can knock some of those out before we wrap things up. So let me go through our member dashboard area first. Oscar says he just took the Mag 20 lecture last weekend. Fantastic compliment to Andrew's level 1 class. Very kind of you to say that, Oscar, and I would agree wholeheartedly. So, folks, the reason I do Law of Self-Defense is back in 1996, I took a course that is now called, it had a different name then, but now is called Mag 40. Mag 40 is the Masada Ayub group. Masada Ayub is a defensive instructor, career cop, now retired in Florida. And I can tell you that in 3 years of law school, we spent almost no time talking about self-defense law. And when I got to Mas Ayub's course, Mag 40, it was then called Lethal Force Institute 1, it blew my mind. It was a week of shooting, tactical use of a gun on a range, and a week of classroom work that focused to a large extent on self-defense law, usually in a kind of general principles kind of way. But Mas is a very effective teacher and speaker, and he opened my eyes to an entire world of law that I had really no idea existed before. And it was shortly after that that I made the decision to focus my own legal practice exclusively on self-defense law. Now, having said that, it may seem that while the stuff I teach and the stuff Mas teaches is they're both self-defense law, they must be very similar to each other. They must be duplicative of each other. But as Oscar here says, it's really not. They're really very complementary because of the different contexts in which the content is taught. So Mas was a cop as a career, so he teaches this stuff from the perspective of a law enforcement officer. And of course, he'd be the first person to say he's not a lawyer, so he tends to teach kind of generalized concepts as opposed to specific statutes, court decisions, jury instructions. And he brings that cop perspective, which is very valuable. My own perspective, of course, is quite different. I've never been a cop. I'm just a lawyer. So I teach this from a lawyer's perspective, having to build and attack these narratives of guilt and innocence in a use of force case. And my approach is much more law specific. So we spend a lot of time looking at specific statutes, jury instructions, court decisions. And I have a lot of my students who've been through Mas's courses, and a lot of his students have come through mine. And invariably, I hear exactly what Oscar says here, and that is that they find the two classes to be not duplicative of each other at all, really, but highly complementary to each other. By the way, folks, if you have an opportunity to take one of the MAG courses, MAG 20, which Oscar mentioned here, is very much like the course I took in 1996. Except mine was 40 hours, half shooting, half classroom. I believe the MAG 20 is just the classroom portion of that. But in any case, if you have an opportunity to take any course taught by Mas Ayub, you'd be crazy not to take advantage of that opportunity. So I urge you to do that. Ram asks, in Colorado, is a person in their car highly defensible property? Well, unfortunately, Ram, we have people in this participating in the show from all 50 states, and I can't possibly step through state-specific law for all 50 states. We do have state-specific courses that dive into every state's use of force law in great detail and answers that and about 100 other questions that you might have about your state-specific laws. You can learn more about those courses at lawselfdefense.com/state. Oh, Oscar says he also, yes, Mas was kind enough. Here, I actually have the book right here. So the current edition of our book, Law of Self-Defense, 3rd edition, Mas was kind enough to write the foreword to that book. Thank you very much, Mas. And Oscar got his autograph on his copy of Law of Self-Defense, 3rd edition. Pretty cool. Let's see. Yeah, so George says, last week during the News and Q&A show, he asked if the $12 million settlement in the Breonna Taylor case, if that settlement might have been made because the town officials who agreed to that settlement with the lawyers representing Breonna Taylor's family. Breonna Taylor, you'll recall, was the black woman killed by police serving a warrant I'm blanking on the town. It's not really important. But the cops were serving a warrant. They got shot at. They returned fire. They killed Breonna Taylor. And as in many of these cases, there was this was purported to be another example of police racist murder, just another of the systemic, unavoidable police, unaccountable police racist murder occurring all around America. In fact, and I was of that opinion when the town agreed to settle for $12 million. Louisville, Kentucky is where it occurred. And George and others asked, well, maybe the town knows stuff you don't know, because the grand jury results had not yet been released. Maybe the town had information that I lacked. And then, of course, the grand jury findings, the grand jury basically declined to indict on anything that had anything to do with Breonna Taylor's death. Returned a no true bill. It's a pretty low threshold to get a grand jury to indict. They didn't. So it appears that there were not, in fact, hidden facts unknown to the public that supported the officer's guilt. If anything, all the newly revealed information was consistent with the officer's use of force having been entirely lawful. So it's just the lawyer of the family is Benjamin Crump. It looks like he just got another cash windfall, presumably something around 30%, $4 million of that $12 million went right into Benjamin Crump's pocket. So another win for him. James asks, any comment on the Rittenhouse defamation case against Biden? I don't do defamation law. I would say there's really there's no hope. Honestly, in most of these cases, there's no hope. I mean, Zimmerman certainly tried to sue for defamation after his trial. Ironically enough, you won't believe this when I say it, unless you already happen to know this. The judge assigned to Zimmerman's defamation case against, I believe it was NBC and perhaps other news media as well, for doctoring photos, videos, audio in the case. The judge who was in charge of that civil case brought by Zimmerman for defamation was the same judge who was in charge of his criminal trial and was clearly, to my eyes, antagonistic to Zimmerman as a defendant throughout that trial. And he got her again for the civil case, and she basically summarily dismissed the lawsuit. So Zimmerman really had the basis for dismissing it, by the way, was that Zimmerman was a public figure. Of course, the only reason he became a public figure was because of the media circus. That seems to me ought not be on him. That ought to be on the media he was suing. But nevertheless, that's the judge's call. And usually that's how it comes out. Now, the only reason I hesitate, I would be nearly 100% positive that Rittenhouse has no chance on defamation here, except that one of his lawyers is Lynn Wood. And Lynn Wood got a fantastic settlement for the young man who had was confronted by the Native American Indian and found himself called a racist on all the news media, and then got what I presume to be a very large settlement from the news media in a defamation action. So I would say that Rittenhouse has no chance at all, except Lynn Wood apparently is pretty good at these defamation cases. So I'd like to see him get some money. For sure. James says, I first heard about your law practice and classes from Mas Ayub. Yes, I've been very fortunate for Mas to always say very kind things about my work, and I greatly appreciate it. Okay, that's from our members. Let me flip through now on Facebook, where we always have a lot more traffic. Hey, Will Parker, great instructor up in the Kalispell area of Montana, almost Canada, not Canada, but pretty close up there. Great instructor. If you're in that neck of the woods, I encourage you to look him up. And very experienced in self-defense law. He's a graduate of our law self-defense instructor program. Alan mentions, just finished Law Self-Defense, the book, great info and refresher after 40 years in law enforcement. Yeah, unfortunately, I mentioned earlier that lawyers are not really taught much self-defense law in law school, and the truth is cops are not taught the self-defense law they ought to be taught at the police academy. Now, they're taught more than lawyers are taught, based on my experience, that's for sure. Unfortunately, most of what cops are taught is not intended to protect the cop from criminal liability, to prevent the cop from going to jail for an unlawful use of force. What he's taught is largely intended to protect his department from civil liability if the department sued over that officer's use of force. And it's really not quite the same thing. The department's interested in saving money. They're not, based on what they teach, they're not really interested in saving the cop. Keith asks, what factors did I utilize when deciding which company was best for my family? Well, there's a lot of them, but one of the two of the biggest factors for why I chose CCW Safe, and this doesn't mean they should be the most important factors for you. None of these programs are perfect. None of them is a perfect fit for everybody. But two of the factors that were most important to me was that most of CCW Safe's competitors had a cap on how much they would provide for criminal legal defense. So, for example, this Kayla Giles case where USCCA is being sued, the platinum level program she signed up for apparently privileges her to receive up to $150,000 in criminal legal defense funds from USCCA. She was provided with $50,000, and then USCCA cut her off. She's suing for the remainder of the $150,000. But the truth is, folks, $150,000 is not enough for a killing case. If you've killed someone in purported self-defense and you're facing a murder or a manslaughter charge, $150,000 just is not enough. When Kayla Giles filed her lawsuit against USCCA in federal court, for the remainder of the $150,000, she'd already run up $150,000 in legal expenses, and she's not going to trial until I think it's now spring of 2021 is the new trial date. So she's not even close to going to trial yet. She's already run through $150,000, and that was in September of last year. So certainly the number must be higher now. So in other words, even if USCCA had paid the entire $150,000, it would hardly have covered her full legal expenses. In contrast, CCW Safe does not put a cap. They will pay as much for your legal defense as is reasonably required for the legal defense, based on standard legal compensation rates and expert witness pay and that kind of stuff. So that was one reason. There's no cap, and you don't want there to be a cap. If there's going to be a cap, it should be on the order of $1 million for criminal legal defense. Now, don't get confused. Many of these plans have criminal legal defense payment. For that platinum plan from USCCA was $150,000, and then they have civil liability coverage, which under that same plan would be $1 million for civil liability if you're sued and the other side wins and they're awarded a judgment against you. USCCA would, I guess, if they felt like it, cover you for up to $1 million. But that $1 million, not a penny of that is for your criminal legal defense. Your criminal legal defense is capped at the $150,000. So CCW Safe, in contrast, does not impose that kind of cap. So I don't have to worry that I'm going to exhaust my share of the resources of my financial partner well before I ever get to trial. And it's very common, by the way, to run through $200,000 pre-trial in a murder or manslaughter case. The other reason I chose CCW Safe or preferred it was because their national trial counsel is Don West, Attorney Don West. He was one of the attorneys for the George Zimmerman trial. And folks, I watched every minute of that trial. In fact, I watched more than the trial. I watched the pre-trial proceedings, all of that. And that was a perfect legal defense. Perfect. And they could have screwed it up. I mean, I see legal defenses get screwed up with regularity. Some of these high-profile cases, the Michael Drake case, the handicap shooting spot case, readily comes to mind, where, man, oh man, that legal defense team just did not bring it. Well, Don West and Mark O'Mara in the Zimmerman trial brought it every single day and overcame some of the most unethical behavior I've ever seen from prosecutors in that case, and what I perceive to be an incredibly biased judge in the case as well. And they were just perfect. Now, if you ask them, they'll tell you, well, we got the acquittal for George Zimmerman, and we should have because he was in the right. And that's true. They should have won. The law and the facts were in their favor. They should have won. But they could have screwed it up, and they didn't. So I think the world of Don West. Since I didn't know Don at the time, since then we've become pretty good friends. And if you have Don West on your legal team, even if it's only through being a CCW Safe member, you are in a much more advantageous position than you would be without him. No doubt about that in my mind. So those two factors were key to me in choosing CCW Safe over alternatives. Let's see, what do we have? Someone says, very neat chart. That was the mini monster chart. I want to emphasize again, this chart is not my creation, folks, so I take no credit good or bad for it. I'm going to pop it back up on the screen. It does have a couple names on the bottom if you'd like to look it up. Just David Myers, copyright 1982. I guess it looks like it might have been in a book called Close Quarters Combat, or maybe another book, Defensive Tactics with Flashlights by John G. Peters. So if you'd like to look it up and dig into more detail, certainly I would encourage you to do that if that's of interest. It doesn't really have anything to do with law of self-defense, however. Let's see. Terry says, recently I read that a newly elected St. Louis DA conducted a secret investigation of Darren Wilson, the officer who shot Michael Brown in 2014, to reopen the case. So that new district attorney in St. Louis reopened the Michael Brown case. It was, let's see if I can pull all this down. Sorry, folks. He campaigned for district attorney on the promise to reopen that case. Now, the case, of course, had already been put before a grand jury by the previous district attorney. The district attorney, this new guy, beat, and one of the reasons he beat him was his promise to reopen the case. It had also, of course, been reviewed at the time by the Barack Obama, Eric Holder, Department of Justice, and they found no reason to bring charges against the officer. The grand jury, of course, refused to return an indictment against the officer. This guy reopened the case. He could do that as a new district attorney. There's no double jeopardy protection, folks, from a grand jury declining to indict. So a new prosecutor could, in theory, reopen the case. Fortunately for Wilson, the new DA opened the case, looked at the evidence, and saw there was no case, just like everybody else had seen. So fortunately, that's a good thing for him. Now, I will say it could have gone otherwise. Obviously, the evidence that was reviewed hadn't changed, and Officer Wilson, Darren Wilson, has been smart enough to basically disappear off the face of the earth since that event. But you can imagine if he was, say, giving interviews about the case and therefore generating new prospective evidence about the case, that the new DA evidence as an excuse to reopen the case, put him before a grand jury, get an indictment, drag him to trial, even after all these years. Fortunately, Wilson was smart enough or got good enough advice to just keep the low profile he's been keeping. And I think that's the best prospect, he says, for a safe life. Let's see. Paul says he recommends our Law of Self-Defense Advanced class. Again, that's this Saturday, folks. This Saturday, the last one for at least 6 months. So do yourself a favor if that's of interest. Let me pop that back up so you can see the URL you would need to go to for more information. There it is. Law of Self-Defense Advanced Live Online class, Saturday, October 3rd. Go to lawofselfdefense.com/live online. Ken asks, I showed the pepper spray. Can I show my pistol? Not today. Yeah, so Brad mentions he's a former law enforcement officer, not a fan of pepper spray. You know, none of these defensive tools are magic. None of them are the perfect solution to all problems. All of them have their drawbacks. That's certainly true for pepper spray as well. I do encourage people, if you're going to carry pepper spray, don't just pick it up at Home Depot or something, a Target, wherever they sell it. Believe it or not, when I lived in Massachusetts, you needed a gun permit to buy pepper spray. But don't just pick it up someplace and just carry it around. Get trained in its use. Believe it or not, there are right and wrong ways to use pepper spray. You don't want to be using it the wrong way. All right, folks. Well, I see we're at the top of the hour. There's more questions in the comments. That's all I can get to. However, I want to respect everybody's time. Remember, we do this every Thursday, 4 p.m. Eastern Time on our member dashboard on Facebook and on YouTube. And if you like this kind of content, you could do worse for yourself than becoming a Law of Self-Defense member. You can, let's see, that's not the right slide. Let's try this one. You can try out membership for just 99 cents for 2 weeks. Full access to our content at lawofselfdefense.com/trial. And until the next time we meet, just remember, if you carry a gun so that you're hard to kill, which is certainly why I carry a gun, so I'm hard to kill. My family is hard to kill. You also owe it to yourself and your family to make sure that you know the law so that you're hard to convict. All right, folks, I'm Attorney Andrew Branker for Law of Self-Defense. Until next time, stay safe.